Right, so Wayne, we're here talking about the book. I want to just ask you about your chapters and what you were trying to do, what your main ideas are that underlie the parts of the book that you wrote.
Well, if we remember, we were trying to identify current politics. Of course, common law is an historical tradition, but we were trying to identify where it is now in the UK, given the UK is, of course, the father of the common law, but given that we're in a globalised world, and our own backgrounds, yours, Manchester.
Manchester Poly, as it then was.
Yeah, mine, South Island, New Zealand, a rather white environment, probably whiter than Manchester is today, probably certainly a lot whiter, a lot less international than London where we are today. And also we wanted to bring out perhaps our experience from our life.
Yeah.
And you did Manchester Poly, I did Canterbury, New Zealand in a 1970s, late 1970s. My interests, of course, were rugby, as any New Zealander would have. A bit of cricket and not so much wine then, but the old beer. And I was this young guy from a small town going to Canterbury. And what was law? What was the study of law? It was turning up to massive lecture theatres, and in particular this rather small lecturer who always lectured in a black gown, and I relate this in the text, that we gave him all this authority because he had been a public prosecutor in Kenya under the time of the Mau Mau insurgency. And he apparently had been responsible in one way or another for the death penalty for several hundred people. And we didn't have a clue what the Mau Mau insurgency was, and there wasn't the internet then. Where would you go to find out? You'd probably have had to have done a library search. We just assumed that he was a great man. It was only later, of course, we realised the Mau Mau insurgency is a colonial struggle in which all the power of ideology is used and all the power of the law. And it is the example, as we know, the English common law or the British common law creates a space for itself to be its own exception.
Could I ask you about that? Because I think one of the ideas that certainly to me is very much part of your sections of the book is this concern with the post-colonial, which is often, it's quite a difficult term to explain. In talking about your life, you get a sense of your own involvement with the post-colonial. But I was wondering if you could perhaps say a little bit more about how, your understanding of this term. It clearly comes out of your life, but how do you perhaps understand this term more broadly as a way of thinking, perhaps more generally, about the common law?
Okay, well, obviously our readers will come from a variety of countries, and our experience of teaching in the University of London's international programme has taken us to many countries: Malaysia, Singapore, Bangladesh, the Caribbean. And all of those countries, of course, the common law came on the shoulders of the English, stroke Irish, stroke Scottish.
Absolutely, yeah.
And the myth is, of course, that it slowly and without any problems dropped off the shoulders and became part of the living fabric of the society. Of course, we know there's a few guns attached. Yes. And today, we are moved on.
Well, we hope we have, or...
we're moved on in many respects, but the common law is, one of the two great secular legal traditions in the world.
Yeah.
So how do you think of it? How is it thought about, by people like me, for whom in New Zealand I would just be assumed as one of the defenders of the traditions that were brought, though not necessarily. I can still remember actually standing up in a public meeting and defending the right of New Zealand to tour apartheid South Africa. Within a year of leaving New Zealand, how could I have ever thought like that? Which is, in many respects, a post-colonial thing.
No, I mean, the post-colonial as a historical periodisation of the post, of the after the colonial. I mean, I think that the sense of how the world changed, certainly after the Second World War, which is in a sense slightly later to the story, or the conventional story of the spread of the common law. I think what my sense of our book is that you were dealing with that much more, that much greater stretch of history. Whereas, when I was talking about human rights, it's really the post-1945 world. And there's that difficult question, I guess, of how these two things fit together or don't. Is the phase of the post-colonial, which arguably we're still in. I mean, that period, certainly from 1945 onwards with the Universal Declaration, is also in a sense the modern period, the period that I think at least my parts of the book were
As you can see, that's dynamic in a whole variety of countries, where the relationship between the Maori and the Pākehā in New Zealand has been energised both by the reinterpretation of Treaty Waitangi and by the introduction of the Bill of Rights, and that gives rise to a much more activist judiciary, which is what we are trying to say is happening here as well, that the advent of the Human Rights Act and now the advent of the Supreme Court is giving a different dialogue between the judiciary and the executive and others.
No, I think that's true. And again, to just try and get to perhaps some of these, the bigger ideas that we were using to organise the book. I suppose one of the themes in that post-1945 period, although in some senses much more recently, is both the impact of European Union law on the common law and, of course, also the impact of human rights on the common law. You used the word globalisation, or globalised world, slightly earlier on. I mean, for you, would you link together perhaps this concept? I mean, all these terms are obviously quite difficult to define, but just in terms of, I think, a way into this book, I felt, and I'd be interested whether you felt the same, that in a sense we were linking together in different ways the idea of globalisation, the idea of the impact of European Union law on common law, and the impact of human rights law on common law. Does it fit together for you like that?
Well, the first globalisation is probably colonialisation.
Yeah, no, absolutely.
Whatever the Spanish were doing, what is now South America. And of course, the irony of the development of the common law is that William the Conqueror brought, for many years you couldn't, well, for centuries you couldn't speak English in English courts.
Yes.
The language was a kind of mixture between Latin and
Law
French. It's irony that when we say that the England is, it's the Europe of the non-Europe or whatever, that in fact its most efficient structures of administration came out of a combination of the Anglo-Saxon and the Norman French.
Again, if you rerun that history, if you go back certainly to the conventional historical understanding that the common law as the law of the Norman invader, an imposed law on the Anglo-Saxon institutions, it's almost as if in some ways that's or perhaps in later times, that theme becomes reincorporated into the idea that the EU law is a kind of invasion, a second French invasion, if you like. I mean, there's the Denning case, isn't there, which everybody talks about the tide flowing back up the estuaries. It's another invasion of the common law, but people forget, as I think you're saying, that the common law was French for a long time, historically. It was law, I think of the word taught, these historical remainders are there in the common law. So do you think it would be fair to say then that conventional story of the common law, that kind of organic history of change, was essentially a history of England and our island story, all that rhetoric, which again, depending on who you read and how it's put together, is more or less linked to an understanding of the post-colonial, but perhaps not in in conventional sense. Do you think we're trying to take that story and tell it in a different way? So from the perspective of a globalised world, from the perspective of a post-colonial world, but we have to, and one has to start with the conventional story of the Norman invasion. I mean, it's another version of the myth of the common law. Would you say that's a fair way of trying to get at
Yes, and indeed, I don't know if we want to give anything away about the cover. But
yes,
But
we talk about the cover at the back, because I think the image, images are very important to the book. We could perhaps talk about,
part of the image of this, if someone might see it as a play on Leviathan.
Yes.
When we think of Thomas Hobbes in a 1651 Leviathan, it's actually an attack in many respects on the common law tradition, because for him, this new law, this positive law, is law set by these the sovereign, the site of power, and imposed. It's meant to give peace and tranquility, etc. But the historical idea of the common law, which Hale had at that time, was of it bubbling up, and the judiciary being the spokesperson for common sense.
The law in the breast.
Yes, Blackstone's declaratory theory. But with what we have here, of course, is our Leviathan has a whole lot of plastic cows, and it's might be an effective method, but it's also a pastiche.
Yes, exactly. A retake of the.
And this is actually quite interesting because what is power in this globalized world today? Is it a power that's organized by the centers of traditional governmental authority, or is it much more diffuse? And I thought we were trying to, in a sense, argue that it's much more diffuse.
Yes.
And that, of course, and we can see that in the modern politics of common law. In the last 15, 20 years, for example, the amount of judicial review has just gone astronomical. We know the problems with legal aid we've got, partly because, of course, legal aid kind of expanded to fulfill people's desires to use courts, to have a sense of not just abstract justice, but real justice.
Yes.
And then this becomes very difficult to put limits on. And so the common law today, in many ways, a mediating force between different things.
I think that's interesting, because one of the themes that I think run through the book, but you can imagine if you rewrote it or if you thought about it differently, you might get to this idea that we are now within this, and this again is perhaps can link it to globalisation. Certainly, we are within market economies, neoliberal market economies. The question of how the common law relates to the market economy and to the question of power that you were talking about, I think that's very, very interesting. And I think that crops up every now and then in this book, because there's almost this kind of tension, I can't help thinking, between an idea of human rights, which is, I don't want to overplay this theme, but at least to some extent resistant to the market, not understandable in terms of a market logic, let's say. In fact, it protects the dignity of the human being, and in certain senses the dignity of the human being is beyond value. It can't be traded in a market, everything can be traded. So there is a sense, I think, in which at least one of the themes or the spirits of the common law that's there in that book perhaps communicates with this sense in which the common law is not simply about market economy, as some of the kind of American law and economics understandings have, which even in a sense replace the logic of law with the logic of economics. I think that the theme in our book is a resistance to that. I think it's implicit. I'm not sure this becomes explicit in the book, but in terms of the common law as a way of mediating these tensions that are increasingly linked to market economy. So you take a theme like legal aid, which essentially was part of the welfare state, which of course is not particularly a common law invention, but is one way in which certainly ideas of rights get linked to understandings of human need, which are not necessarily satisfiable by markets, and thus legal aid, to I suppose link the story much more to law, is that way in which people should be enabled by the state to pay for things which they wouldn't otherwise be able to afford, so healthcare, education, what have you. It seems that history is bound up, and there's broader claims, I think, to be made about the common law in that political space, or that concern with
well, if you look at some of the so-called leading cases of the common law, Donahue and Stevenson was a pro bono case.
Very interesting.
It would never have, this whole change would never have come up apart from the fact that a certain number of barristers thought that it was a very good case to argue, and did it for free, because Mrs. Donahue, or Callister, was, as the head note of the case always puts it, a pauper. And there you can also see in that case, we don't spend a lot of time on the book, it's only vaguely mentioned, but of course you can see in that case a clear distinction between Lord Atkins' pursuance of principles and Lord Buckmaster's argument that it would be just intolerable to impose a duty on the manufacturers. Lord Buckmaster gives an answer that's drenched in economics, and he gets the economics wrong, because why do we buy these bottles of Coke today that we can't see in it? Because we know if there's a decomposed snail or indeed a mouse in it, that we will get money back. The common law, as it's been viewed both by its own writers and I think by the public, does in a sense stand up for something other than the market.
No,
it cannot
yes.
be reduced. Yes.
I think it's a complicated thing, and I think it's a very pressing issue for our time, if you like, that troubled, complex relationship between an economic logic and a social logic or a legal logic. I mean, one thing I think is for sure, they don't easily map onto each other. In other words, I think I would resist the idea that economics explains law. I think law has to be used to explain law, if you like. And if you take that model of how you talk about the law, how you explain the law, because I think we, when we were writing it, we were aware that it wasn't a usual textbook for any number of reasons, and I think we were resistant to the idea that it's a textbook. We thought of it as a set of kind of interlinked essays or what have you. And I'm just trying to perhaps get at that sense in which, I mean, you've talked about the way in which you're very explicit about your own biography being bound up, in a sense, with the history of the common law and its effects, its ethos, if you like. I mean, and you've talked about the way we've used the images on the front of the book, the Welsh photographer Peter Finnemore. In fact, the first edition of the book has got another Finnemore image on it as well. In terms of the images in your chapters, the hay boss image that you used, I'm wondering if you could perhaps say a little bit about the peculiar form of this book. Not a textbook, a set of essays, pretty much bound up with both a personal and a political history of the common law. How perhaps your use of images as a way of talking or explaining or trying to get at the peculiarity of common law work?
Well, if we were to think of the common law as, I take a quote from Bentham, as a thing imaginary, and you flip that round and say, well, it's a thing of images, yes. And we asked that about the hay boss image. I mean, this, of course, is a play on one of the great images of English countryside, beauty.
Yes, exactly.
John Constable, not so long, far away from here, is it?
No, but I mean, if you think about a lot of law textbooks and the images that are used on the cover, they're fields, the island story again, the imagery, the iconography of England.
The beautiful countryside that's meant to also fit with the slow development of the common law.
Yes, exactly.
The spirit and the greenery and the people. And of course, what happens here is that hay boss is on first sight it looks like a direct copy of John Constable's A Hayway. And then you notice this little figure in the background and this little voice thing up there saying "Hey boss," and you find it's written by Australian Aboriginal from Northern Territories, and what he's saying is that when you came to Australia, your right to come was claiming that Australia was terra nullius. It wasn't organised. It didn't have a people that was cultivating the land, and it didn't have a sovereign to defend it. Well, he's saying, well, if I come here, what on earth have you done to this place? Nothing in this place is the way it used to be. Have you really saved the forests? Have you really lived in accordance with the rhythms of the land? And he's trying to say, well, no, you haven't. So have I the right to say that, can I have England, please? And we, of course, he's playing on a thing that most people would say, oh, get away, you little troublemaker.
But it's running the story in reverse, isn't it? I mean, that whole doctrine, again, of terra nullius and the way it's used in colonial law as a way of essentially stealing land, interestingly, I think, does link back to this whole way in which the spirit of the common law, its institutions are embodied, not just in a landscape, in a history, but in institutions. Now, I know that Rob's chapters were very much concerned with those institutional forms that law takes, civil procedure and criminal procedure, and you were very, I mean, I think again...
But also the chapters we worked on about Griffiths. What is the politics of the judiciary today, and whether Griffiths' view, which was kind of like a Labour Party view, from the 70s and the traditions of the way in which to be a member of the senior judiciary, you all really have to be a member of the Conservative Party, kind of stuff.
Yeah.
But that's, it's a lot more complicated today, in that as of course the numbers of the judiciary have expanded, as of course the number of barristers have expanded, as the number of all other legal offices, if you like, have expanded, can you talk of any kind of settled culture of being in the judiciary, or being even in the being a barrister, which once upon a time you could, when you had to have all your terms, you could talk of a tradition being kept alive by the Inns of Court, by the golfing, by the common drinking and eating.
Right.
Today,
this is, I think, again, another really important concern here. I mean, to go back to the idea of an institution, and to link that with the idea of an ethos or a spirit. Common law is a spirit. And that spirit has to be communicated in certain ways. So if you think of the ethos of the common law, you will think of common dining, you will think of these common rituals that hold together, particularly common lawyers, I suppose. And to revert back to, I suppose, a set of earlier themes, and the challenge for the globalised common law now is precisely what this ethos is, given that we are a long way from, these rituals persist, but the question is, I suppose, to what extent could new rituals be invented that communicate the ethos of a common law that is now no longer simply that of English common law, but so plural, so different. I guess that might be another book in itself.
Well, indeed. Hopefully has a travel budget approached it. And some wine. We have to cut that bit out.